The warrant that was issued last winter, which then resulted in his apprehension and ultimate return to Washoe County.
All rise. The Second Judicial District Court in the state of Nevada is now in session. The Honorable Barry Breslow presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. All right, we're on the record in case number CR 19-1535, A and B, State of Nevada versus Mr. Hillygus and Mr. Handte. The court acknowledges prosecutor Mr. Stege, defense counsel for Mr. Handte, Mr. Silverberg. Mr. Hante's present. Nice to see you. Good morning. Standby counsel who filed notice of acceptance of appointment of standby counsel, Ms. Reynolds, and also Mr. Hillygus. Welcome. Court set this hearing on an expedited basis after the court learned that Mr. Hillygus had been extradited back to Nevada. Multiple reasons. First, the court wanted to reset the psychological evaluations, the two, one by a psychiatrist, one by a psychologist, that the court had previously ordered last February. The court did not want Mr. Hillygus to linger in the Washoe County Jail unnecessarily while these were being reestablished. The court also wanted to have standby counsel for Mr. Hillygus's benefit so that if issues arose in the manner in which these evaluations would be reset or conducted, he would have the ability to confer with such standby counsel to assist him with respect to his legal rights. In addition to that, of course, after the evaluations occur, we're all aware that in the event a conclusion is reached which is inconsistent with either party's view of what the evaluation opinions should have been, either party has a right to challenge or traverse the findings. And so the court wanted to make sure that Mr. Hillygus had the benefit of standby counsel in the event the evaluations occur and he disagrees with their ultimate conclusions. Also, we are aware that if when the evaluations go forward, it's possible that of the two evaluators, they reach inconsistent conclusions, in which case the court generally appoints a third evaluator to use a term, break the tie. And then that informs the court of possible outcomes. Aside from the competency evaluations, the court wanted to make sure Mr. Hillygus had the benefit of standby counsel to assist him with any attempts to change his custody status. The warrant that was issued last winter, which then resulted in his apprehension and ultimate return to Washoe County, can likely be viewed as now subject to the recent Nevada Supreme Court decision in Johnston, where there's a pretrial violation. Somebody has their out of custody status revoked, they're apprehended, and then generally they're entitled to a prompt hearing. This case is nuanced because the court had concerns as to Mr. Hillygus's competency to proceed to adjudication. And so the issue of what his custody status is or will be in the very near future is in part a product of the evaluations. We also are aware that the evaluations are taking some time to occur. And furthermore, in the event the evaluations lead to a result, an opinion and a finding by the court that at this time Mr. Hillygus is not competent to proceed to adjudication, then that opens up a whole nother group of questions with respect to how he would be treated to competency. But of course that may never happen. It may be that he's evaluated and the evaluators conclude that he's competent to proceed. So, and then finally, the court wants to observe that we have in the Mr. Hante's case, we have an upcoming status hearing in February, which is designed, among other things, to address any pending pretrial motions. And the court is aware that filed yesterday was a motion to seek to change Mr. Handte's custody status, in particular the GPS device, because of the contact dermatology concerns, and also the fact that it's now felt by the defense that it's punitive. It's not, it's no longer a public safety issue or to secure his participation. But, you know, Judge, it's been enough time, let's get it off. Now, we're not going to address that today. Why? It was just filed. It was just filed. The state has an opportunity to respond, reply, and the court will have a hearing. Right now, the court intends to address it on the record at the early February status hearing. So get it briefed, fully briefed, submitted. In addition, the court can consider it, and the court will take another look at it in light of how Mr. Handte's been conducting himself while on pretrial release. I'm not aware of any issues. So that right now is favoring the motion. And I'm understanding if there are medical reasons, before they were identified to the court, but not in the type of terms that the court felt were so compelling as to grant the motion. But the court will take another look at it in light of the time that's expired and any current medical condition. So I want Mr. Handte and his counsel to know the court's not tone deaf to these requests to remove the GPS. It will be taken up and decided no later than at the February hearing. So let's talk about who does the evaluation. Let's go back in time to February. The court, I don't want to be guilty of hyperbole here, but the court moved a couple mountains to line up 2 evaluators to come to the courthouse on short order in successive days or successive weeks at least, to come evaluate Mr. Hillygus at a time when there already was a over request for such people's expertise, and there were really was a shortage of qualified professionals. So the court moved forward as rapidly as it could to line up these evaluations, but they did not happen. Mr. Hillygus did not appear. Right now, I am unaware if there's any current protocol other than the court seeking to set up these evaluations to have Mr. Hillygus reviewed and evaluated. Maybe there's a new normal, maybe there's a new protocol, maybe the Washington County Public Defender's Office, overseen by Mr. Arascata, is efforting that. Maybe the Washington County Alternate Public Defender's Office with Mr. Picker, or more, maybe the state has insight to that too, because of the challenges in getting people timely evaluated. But right now I want to discuss how we move forward with Mr. Hillygus evaluations. I want to discuss when we would possibly set a custody status hearing, and then when we would set a competency hearing, among other things. Mr. Stege, why don't you give the court the benefit of your thoughts based on what you've just heard from the court and anything the court may have overlooked.
My thoughts on this issue of competency. Of course, we all professionals know that competency can be fluid and often is fluid. This instance, right, we have to go back in time for this. Strikes me as sort of what the psychiatrists will, because of the sort of bizarre views but not delusional views that the defendant has, are probably not a barrier to competency. That's sort of my experience speaking on this issue. But we all know, of course, that any party can raise competency, which the court rightfully has. As to the procedure of it, I see no reason why we should not follow the ordinary procedure that we would follow with any other defendant, which is to appoint 2 people qualified to conduct the evaluation.
Who appoints them? Because last time the court took the lead on getting people appointed. The court didn't pick the individuals. Right. The court just emphasized the need to move this forward quickly, so we would hopefully not disrupt the adjudicative process and move the matter along so people didn't have to linger.
Yes.
Is that still the process as You understand it? Or is there somebody now, the court ordered, reordered these evaluations, who actually does what?
I will defer to my defense colleagues.
Well,
or
and
more.
Mr. Gaynor might have some insight too, because this is something that we've been having come up from time to time lately.
Yes, but the issue of sort of expediting, I think, is now, that ship has sailed, given the sort of the wrongdoing of the defendant. I think there's a strong argument for his, his forfeiture of any sort of complaints about delay by his deliberate and intentional flight from the jurisdiction, and long time flight, very elaborate.
So wait in line like everyone else. Is that it?
Why not? Nothing special about him, I submit, right? As opposed to any other defendant. Nothing special about him, except for that he fled the state. Everything special about him speaks to not moving him ahead of the line for any reason.
All right, what about a Johnston hearing at some time in the foreseeable future here to address his custody status?
It's an interesting question, because of course competency, you're supposed to suspend proceedings.
I understand that, but
Nothing happens when proceedings are suspended. I'm happy to do that. I don't know, that's sort of a role for Ms. Reynolds and Mr. Hillygus, given those very interesting issues of insistence by Mr. Hillygus that he represent himself in the court's appointment of the PDs for standby.
Well, and let's
purposes.
make sure we're clear as the court understands it. He's still representing himself with two asterisks. First asterisk is there is a competency concern. So the decision to allow somebody to represent themselves when there's a competency issue, we are going to do our best to protect him from himself until that issue is resolved. That is one of the reasons the court appointed the Washington County Public Defender, and Ms. Reynolds is here to assist him through that process. The second piece is that he still gets to direct the course and scope of his defense to these charges. He has the ultimate say, but with the guidance and availability of the standby counsel to answer questions, to take over at some level, to assist and to educate and to instruct if asked. But when with a competency issue question, it really, in the court's view, broadens the scope of the standby counsel to help them and guide this process until a decision is made on competency. And then we get back to how standby counsel would otherwise ordinarily work.
Yes.
That's where the court's coming from.
Yeah, wise course. I would suggest, if we do that, two things: some sort of pleadings, there ought to be pleadings on that subject, so we're not sort of arguing in the dark without the benefit of evidence or facts. And two, we ought to pair that probably with Mr. Handte's, if we're gonna be back here for a bail-related issues, let's do that together, I would suggest, as a matter of convenience.
Well, right now, as I mentioned, we have a hearing coming up, I think the second week of February, where we are planning to address multiple pending matters. The court will move this change of custody status request to that hearing as well, unless for some reason counsel or have agreed to something outside the motion, or alternatively, the court can't get it in at that time. But I want to have it decided no later than then, because this is important to all involved, particularly to Mr. Handte. We will not have, it's hard to imagine we would have two evaluations and be ready to proceed with the competency hearing by that date, just because of the number of other people who are waiting to be evaluated, and then how long the turnaround is. But again, one of the reasons we're meeting today is the court does want to expedite this. Do I want to jump over somebody else? No, not really. But we have a case that's been pending a long time. We have a defendant set for trial in August, and this case is, depending on Mr. Hillygus' competency, would be jointly tried in August. So there are a lot of reasons the court does not want Mr. Hillygus to linger, having a delay associated with his evaluations and a competency hearing. But any final thoughts on him here?
Final thoughts.
Ms. Reynolds.
My observation is that the delay has been mostly with people deemed incompetent and being treated to delay. This initial approach-
Evaluations?
Yeah, the initial evaluations, I haven't seen a lot of delay involved, referring to the wisdom of all of us here. But those seem to be not too long.
Okay, before I hear from Ms. Reynolds and Mr. Silverberg, Mr. Gaynor, with respect to the court ordering evaluations, have we been taking the lead, sending out the order and then monitoring it, or has it been a different approach lately?
No, Your Honor, from my experience, the court will do the order and then it rests with defense counsel
To line it up? Okay. So first of all, Ms. Reynolds, welcome. And I saw that you initially filed a notice of appearance, but that's probably the wrong piece of paper. So you filed a notice confirming appointment, which makes sense to the court here. Based on what you've heard, based on what you understand the role of standby counsel is, based on the procedural posture of this case, let's assume you've had a chance to review it and at this point, maybe you say, Judge, I'm just getting into it, I'm not fully apprised of how we got to this point in time, then I certainly would understand and respect that. But what are your thoughts on issues we've touched on so far, please?
Your Honor, to begin and to start with the competency procedure, a renewed order from this court would be helpful, just given the amount of time that's passed since the prior order.
Okay, who then takes the lead to line up the two evaluators?
And then our office will work with scheduling those evaluations.
Is it with NAFCARE? Is it with a panel now? Because obviously Lakes is not doing this anymore, right?
There, to my understanding, there is a panel now. It's a little bit quicker if Mr. Hillygus would be willing to do, it's not Zoom, but video visit. Remote. Doctors Pearson and Patterson are our two primary providers who do in-person evaluations at the jail. They are running right now between 4 and 6 weeks. I think if we were to do remote evaluations, those, I think a turnaround time of 30 days would be realistic if I let our office staff know that this was a rush.
Okay.
With respect to a Johnston hearing, we would request one at the court's earliest of convenience. I could be available at that February date. Or I even sooner would be my preference.
Okay, any other thoughts based on your review of the file, any discussions you may have had with Mr. Hillygus, what you've heard today or otherwise?
Your Honor, I have reviewed the file, have met with Mr. Hillygus, and agree with the court that I think competency is the first issue that needs to be resolved.
Fair enough, thank you. Mr. Silverberg, any thoughts or comments on behalf of your client based on what you've heard so far today?
Yes, Your Honor. The state indicated that somehow there should be no rush on this based on Mr. Hillygus' conduct, but it affects Mr. Handte as well. We've got an August trial date, we need to prepare. We need to know right now the state's chosen to try them together. So if Mr. Hillygus is found to be incompetent, then does the entire matter get stayed? There's a lot of clarification that needs to happen, so.
So sooner rather than later would be best for all.
Absolutely. That's number one.
Well, I don't know how, let me just pause there. So you've heard me say 3 times now that I don't want Mr. Hillygus to linger in the jail awaiting this process. I didn't want him to be in jail at all. When he didn't arrive to show up to be evaluated, then all this happened. So, and then it took time to get him back here. But let's look through the front windshield and not the rear view mirror. I'm aligned with the idea that we should move these matters forward in a reasonably expeditious way. I'm not gonna step on other cases, other lawyers, other accused, other criminal justice matters. Those people have the right to have their case heard promptly as well. But I'm trying to telegraph here that it's not lost on the court, that this case has been pending for a while, and let's move it forward.
And then just 2 issues, Your Honor. I know we're going to address the motion to remove the GPS.
And by the way, I didn't see the confidential exhibit, the medical exhibit.
Just filed it this morning.
Okay, good,
Thank you.
sure.
My mistake. Mr. Handte has a $400 payment due at the end of the month. I'm going to ask the court to suspend that payment for the GPS until there's a ruling on the motion, if the court can.
So do this at the end of this month for the next month?
Yeah, when's it due?
May I comment, Judge?
Sure, if your lawyer allows you to. Hold on.
So on the 30th, he has a payment due. If the payment's not made, then they'll stop monitoring him and he'll probably get a pretrial violation. So I'm just hoping that we can suspend that until we have the hearing. And I don't know if it's a separate agency, so I'm not sure exactly what the court's, I guess what I would request is if that does happen, that the court not violate Mr. Handte while we have this motion pending.
The request is denied. Here's why. Does anyone want to pay $400 that they are not going to need to? No. And I understand money's tight and for multiple reasons, I get it. The problem is, A, the hearing's in February 10th, 12th, right around there. And B, so we're into that month already. It's not like it's the first or second. And the second reason is, I don't know what I'm going to do. I don't know if I'm going to agree that the GPS can come off. And so that would be premature.
Okay.
So again, I'm going to reiterate to Mr. Handte, if you come here at our hearing and you've been compliant and you're not doing things that make people concerned that you would not appear, or that you are going to leave the area without permission, or that you're going to do anything to try to compromise the jury pool or intimidate a witness, if I hear you're doing well, and based on the length of time, and if I have medical record from a licensed medical professional who says that this is causing you physical distress, I'm going to take a very close look at it and possibly remove that restriction, okay? Now, the other thing is, Ms. DeGana just reminded me, that hearing is not until February 23rd. It's not the 8th or the 10th or the 12th. So that's when I'm going to have a decision on this. It's 5 weeks from now, and that's just how it has to be. All right, what else?
The only other thing that Mr. Handte wanted me to bring up is, I'm not sure, I've looked at the record, mainly focusing on pending motions, but is there a no contact order between he and Mr.?
While here's my recollection of the order, Mr. Stege can correct me if I've overlooked something. The order was, while Mr. Hillygus was on pending warrant status, there would be no contact. Is he on pending warrant status? No, he's been picked up on the warrant. Now, that said, that's the first answer, yes. The second answer is the state might say, Judge, take another look at the order, expand it, edit it,
But at
amend
this
it.
point, that hasn't
That
happened.
hasn't happened.
So there's nothing, I don't want Mr. Handte to
Well,
violate the court order.
he would not violate the order. They're co-defendants on a big case. Now, whether it's a good idea, whether he does it with or without your advice, whether Mr. Hillygus wants to chat about whether that's a good idea with Ms. Reynolds, that's another issue. But right now, there is no order preventing contact.
Understood.
Okay.
And I've had all the proper discussions with my client about that proposed communication. I
Okay.
just want to make sure, if he does that he's not in violation of any order
Okay.
at this point.
Okay. Ms. Reynolds, you want to address the court on that point, then Mr. Stege?
Your Honor, I have no legal argument to add, but I would just like to state on the record that it is a matter of record that the Washoe County District Attorney's Office receives any communication or could monitor any communication that is not between a defendant and their attorney.
Absolutely.
Okay, fair enough.
But only as to the Handte motion, I had stated the last time we were in court, my intention to address that issue. My trial needs have sort of intervened in that, but the court should anticipate that my response will be both direct to basically spying the same letter and asking for the same relief, as well as my own differing views as to Handte's bail status.
Okay, well, that's why we have a hearing. So just to make sure everyone understood what the message there was, the state's going to have a different view of how Mr. Handte is been performing on, may have a different view on how Mr. Handte's been performing on pretrial release, and whether if the court finds excellent performance, should inform the court's decision to change the custody status. The state might say he hasn't been doing what he's supposed to. Or the state might say he's been doing everything he's supposed to, but it's a big legal so what? You should continue what's been working. Why change it if it's inspiring great behavior? So I get it. I understand what are likely to be the different views on this point. All right, so here's what we're gonna do. And you know, Mr. Hillygus, I know it's not easy to sit there and listen to people talking about you as though you're not even in the room. The court acknowledges you. I appreciate you're respectful to this process, and I realize that you know it's an unusual situation here. But I will say this: the court orally renews its prior order, and we'll put it in writing shortly, that Mr. Hillygus be evaluated by 2 professionals pursuant to statute, one a licensed psychologist and one a licensed psychiatrist. I want to set a hearing on the, go ahead.
I'm sorry, could we just say, it doesn't need to be a psychiatrist and a psychologist, I believe by statute, it could be either or.
As in 2 of each?
The statute contemplates a combination of any 2. Could be two of the same
Or 1 of each?
or 1 of each.
Or one of
Thank you
each.
for straightening me out, that's right. I haven't looked at it exactly in a while. Can be 2 psychologists or 2 psychiatrists or 1 psychologist and 1 psychiatrist, all right. The court renews that previous directive. The court will issue an order to that effect. The substantive case against Mr. Hillygus remains stayed pending the determination of competency. I suggest we set the competency hearing on the February 23rd date that we already have for a hearing on motions in Mr. Handte's case. With respect to a Johnston hearing, right now I'm going to pencil it in for that date as well, understanding that, you know, we can all read the Nevada Supreme Court decision. It says prompt, but you know, prompt is a bit objective and a bit subjective. Unusual case here, unusual fact pattern. Somebody who went to another state and had to be extradited back here. So I want to make sure Mr. Hillygus has a right to ask for his custody status to be changed. But right now, it's going to, unless the court finds good cause to change its approach, it's going to be during the February 23rd hearing. I will make sure we have enough time to cover all these issues on February 23rd. Ms. DeGaynor, what time is the hearing currently set for, and how much time do we have blocked out, please?
Your Honor, it's currently set for 10 a.m. to trail the criminal calendar then.
All right, well, let's change that. Let's change that.
Your Honor, the afternoon on that day is open.
All right. Would 1 o'clock work for the state on February 23rd? And then I'll ask the same question for the defense counsel.
Yes.
Yes, all right.
I'll make it work.
You'll make it work and
Yes.
as well. All right, so 1 o'clock, February 23rd, and we'll have the entire afternoon. Mr. Stege, anything else you want to bring up at this time?
Thank you, Your Honor. No.
How about you, Mr. Silverberg?
Nothing, thank you, Your
Ms.
Honor.
Reynolds?
No, Your Honor.
All right, thank you very much, everybody. The court's in recess.
All rise.